ER 316. Ms. Barker is present in court. She is accompanied by her attorney, Ms. Lauren Tuttle. She was last before the court on the 23rd of January of this year, where she entered a plea of guilty to aggravated arson, a felony of the second degree. At the time of the plea, the court ordered a pre-sentence investigation and report, along with a psychological evaluation and a victim impact statement. All of those matters having been resolved to date, we are here today for sentencing.
Thank you. Ms. Tuttle, any reason not to go forward with sentencing?
We're prepared to proceed, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor.
Good.
We would request that the court overcome the presumption for a prison sentence here and sentence Toshana to a period of community control sanctions. Toshana presents a really interesting set of facts and circumstances for this court. She's not the usual offender that we would have come in on a felony of the second degree arson charge. Toshana has one prior juvenile adjudication and one prior adult case. She has no history of setting fires. She has no history of behavior like this. This is something that has come out of nowhere. This is not really something that has been part of her character. In March of last year, Toshana was suffering from some really serious mental health issues. She hadn't left her house in a substantial amount of time. She wasn't behaving normally. On the day of the offense, her family was working on trying to get her the mental health help that she needed, on calling a mobile crisis unit in order to deal with the mental health problems that she had. That's the reason why she was with Miss Angelique and why she was at this specific facility, was to try and get assistance for the mental health issues that she was suffering. Toshana doesn't have a memory of most of this incident. She doesn't remember a lot of what happened. She was really in a dark place at the time that this went on. She doesn't have an idea of why she did this. But Toshana acknowledges her conduct. I've gone through the police reports and the videos with her. She acknowledges that that's her and that she did this. Toshana chose to proceed with a plea of guilty rather than a plea of not guilty by reason of insanity, and to move forward with her case in this manner, so she understands that she's subject to the penalties associated with a felony of the second degree, but would ask the court to take into consideration the fact that she was in the middle of a pretty serious mental health crisis when this happened, that she wasn't fully in control of what she was doing. Toshana has a long history of mental health problems. Starting at the age of 7, she was admitted to Laurelwood for seeing figures, hearing voices, and scratching at her skin, believing that there were bugs crawling on her. This is something that her family has attempted to get her help with for quite some time. This is something that she has sought counseling for. She has a history of physical and sexual abuse that has happened to her. In 2015, Toshana was raped. Following that rape, she turned to drugs and alcohol. There was a history of substance abuse that it began to kind of try and quiet the symptoms that she had faced. She did suffer from PTSD following that. I know it was very difficult for her to try and stop the drugs and alcohol that she was using when she started. Specifically, crack cocaine is something that has been very, very difficult for her. In 2021, Toshana faced the hardest year that she's faced. She went through more instances of sexual abuse. She went through more instances of drug use, and she was really at her lowest and her darkest point. Toshana has achieved periods of sobriety in the past, and where she's been most successful was in dealing with Jordan House. Jordan House is a program in Cleveland. There are members of that program here today that would like to speak on Toshana's behalf. She was able to obtain sobriety there and to do well. Jordan House would accept her to participate in their program again. They would allow her to live there, even being on an arson registry. They would accept her to be there, even understanding the severity of her conduct in the instant case. Toshana would like the opportunity to be able to participate in treatment. She's had about a year sober since she's come into the Lake County Jail. This is the longest period of sobriety that she's had since 2015. I know that she's feeling substantially better. She was placed on Abilify after her time in North Coast. The Abilify has her thinking clearer. Toshana's a bright girl. She graduated from John Hay High School. She was a student at Kent State, but her mental health and substance abuse problems really kind of darkened everything that was going on, prohibited her from being able to move forward with her future. Toshana wants to be able to have a career. She wants to be a drug and alcohol counselor. She wants to help others that are in the same kind of position as she is. But she knows that she needs to deal with her own substance abuse problems coupled with the mental health issues. It's pretty unclear what the underlying mental health diagnoses are here. There's absolutely evidence of PTSD. There have been past diagnoses of bipolar disorder. But what remains clear is that this is something that needs further treatment, help, and assistance, that Toshana does have some substantial and severe mental health problems coupled with substance abuse disorders that may have led to something even like substance abuse-induced psychosis that may have contributed to her commission of the offense here. So we'd ask the court for an appropriate and fair sentence here that allows for Toshana to receive rehabilitation, that allows for her to keep moving forward rather than to set her back, that allows her to stay on medication, that allows her to get counseling, that allows her to deal with these two separate issues that she has of substance use and of mental health problems. Tashi would ask for the opportunity to participate in the Lake County Jail treatment program. She thinks that would be a great start as far as getting some more treatment tools under her belt since she hasn't been in treatment for a couple years. She would ask for the opportunity to go to Jordan House to participate in their inpatient treatment there and to stay there as part of their sober living program. She believes that if she's in sober living, if she has those supports around her, if she's not in kind of a transient lifestyle where she's going from place to place with person to person without stability, that she really can be successful. This is what has proven to work out well for her in the past. This has aligned very closely with her periods of sobriety, and we'd ask the court to consider that as part of an appropriate community control sanction. Thank you.
Thank you very much. You can say anything you'd like. Is there anything you want to say at this time?
Oh, yes, Your Honor. You want to stand?
Whatever you
I'm
like.
sorry?
You want me to stand?
Whatever you're comfortable doing.
I'm
I
sick, 'cause I'm
don't interpret that as any disrespect.
It's easier for you to read this way.
Thank you. Okay, I didn't know what to say, so I kind of was going off of what I remember about.
So try to keep your voice up, though, okay?
Okay, I didn't remember what to say. I was just going off of what I recall about being in here. Okay, so I said, in this past year, a lot has happened to me and changed me. I can honestly say I'm not the same person. Last year, I spent more than half of the year completely paranoid, and for about 4 months, I wasn't in touch with reality. This was mainly between the months of March and June. I got sober the last week of February last year, first week of March maybe, because I was completely at loss with myself and with life. I was hearing voices every day and becoming increasingly paranoid to the point I believed my own mother and grandmother were out to get me. I lost all contact with social media, my AA support group, my closest friends, all of my support, and almost anyone who knew me outside of my mother's house because every day I was in fear. The day of the incident, I remember having the same feelings, and to this day I don't know all the details of half that day. I'm willing to accept the consequences of my actions and I take full responsibility for what occurred, but that is not who I am. I love Miss Angelique and I would never do anything to hurt her or cause her any intentional harm ever. The person I was back then was arrested and had no clue as to where she really was for months. I remember being in a cell not eating because of the voices telling me it was poison. I remember not showering for 6 to 7 days at a time because of what my mind was saying and revealing to me. I couldn't use the bathroom for 4 to 5 days at a time. I was in fear of the people outside of my cell because I couldn't comprehend what was actually going on. I recall a CO helping me to the shower after me being strapped to a chair where I urinated on myself constantly. Everything I went through from the day before that fire until after I was medicated and stabilized was pure mental torment and anguish, and that was the only reality I knew for most of 2022. I was used to hiding my face from cameras. Even when I got to North Coast, I couldn't sit in front of TVs because the light was a recorder, so I was told. I believed that people were reading my mind because of the voices in my head. I could not sort the truth from reality until Dr. McCormick took time to work with me. He explained who he was. Without me giving voice to what I was experiencing, he did. He was the first person to understand. I never would have even guessed, let alone know that I was in a psychosis had he not explained it to me with the diagnosis. Then 2 women started coming to pray with me regularly. It took a full 2 months at North Coast for me to even understand that there had been a fire and I was the accused. I take responsibility for my actions because that is the type of person I am. But I am not a pyromaniac nor a criminal. I am someone who checked out of reality and made a heart-wrenching mistake that to this day I can't even fully recall the details of. I am sorry and I want you to know that I have every intention on righting my wrongs. I personally believe that this was a result of drugs I was doing and me not tending to my mental health properly. I refuse to allow that to sound as an excuse though. I'm just saying it to say that my recovery matters to me. My decision-making is of importance to me today. My life matters. I was enrolled in Edwin's culinary arts program and supposed to start the week of the fire. I was trying to do everything right, even with paranoia. I was fighting the fight of my life and forcing myself to do things that went against my fears so that I could overcome everything hindering me at the time. I intend to continue to do right. I'm just asking for a chance to prove it to you. Thank you.
Thank you, Ms. Barker. Kyle, is there anything else you care the court to
No.
consider?
Thank you, Your Honor.
The state of Ohio, Ms. Mulligan?
Thank you, Your Honor. It's the state's position that based upon the seriousness of this offense, that a substantial prison term is required. Acknowledge that the defendant appears to have a history of psychological troubles, but she's provided this court with no viable alternative to prison here, that she's chosen not to pursue an NGRI. She wants to go to a program that she's been to before, and they say she's successfully completed, and yet she is here before you on a very, very, very serious charge. Troubled with this psychological aspect that her primary diagnosis that she presents today is of malingering. I think that in order to punish and to protect the community, the state is asking the court to impose a significant prison term. The state has made attempts to reach the victim in this matter for evidence of her financial loss, but we have not received any response to that.
Thank you. Before the court imposes sentence here, I need to advise Ms. Barker of what her duties and responsibilities will be to register as an arson offender, which she'll be required to do regardless of what sentence is imposed by this court. So I'm going to do that now, provide her with the proper paperwork, and then we'll proceed with sentencing. I'm going to read this to you at this time. You're going to get a copy of this. I'm not expecting you to memorize what I'm telling you, but if you have any questions, make sure you ask. That I am required to do this. You have been convicted of or pled guilty to an arson-related offense. You will be required to register in person with the sheriff of the county in which you establish residency within 10 days of being released from incarceration or within 10 days of your sentencing hearing if you're not sentenced to incarceration. You will be required to provide the sheriff certain information, including your social security number, full name, and any alias that you may use, your residence address, information regarding the offense of which you were convicted or pled guilty, a description of any scars, tattoos, or other distinguishing marks on your person, the name and address of any place where you are employed or attend school, any driver's license number, commercial driver's license number, or any state identification card number issued to you, and the license plate number of each vehicle owned or operated by you or registered in your name. The vehicle identification number and the description of the vehicle must also be provided to the sheriff. Now, you will be required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of your registration. You will be required to remit a registration fee of $50 to the sheriff unless that fee is waived. After the date of initial registration, you will be required to re-register annually, meaning once a year, every year. You must update and or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially registered. If you are re-registering in a different county than your prior registration, you must provide written notice of your change of address to the sheriff with whom you previously registered. You will be required to pay a re-registration fee of $25 to the sheriff's department. Now, you are required to comply with all of these above described requirements until your death, unless the sentencing court determines otherwise. Since your expected residence address is located in Cuyahoga County, you will register in person no later than 10 days after release or sentencing if you are not subject to incarceration with that county sheriff's office located at 1215 West 3rd Street, Cleveland, Ohio 44113. Now, your failure to register or failure to verify residence at the specified time will result in criminal prosecution. Ms. Barker, do you understand the conditions that I've just explained to you?
Yes, sir.
Do you have any questions for me at this point? Again, you're going to be given a copy of this, but any questions?
No, sir.
All right, then I'm going to have the bailiff provide you with this document right now. And in line 10, it reads, I acknowledge that the above requirements have been explained to me. I understand the requirements and that you must abide by all the provisions of Ohio Revised Code Chapter Sections 2909.13 and 2909.15, which is the revised code that sets forth what I just explained to you. On line 10 is where you're acknowledging that I read it to you and that you understand it. You sure you don't have any questions for me?
So this is without a question for the rest of my life?
unless, I mean, there is provisions that it could be changed, but that has to come from the judge unless you apply for or file a motion and the judge grants your request to stop that at some point, you would have to do that. But there is a provision in the revised code that would allow you to request that at some point you don't have to do that any longer. But you'd have to make that motion and it would have to be granted by a judge before you can do that.
Minimum of 10 years?
That's what you're going to talk about.
Okay.
Let's just make, you have to continue doing it after 10 years unless the judge grants a motion.
Right.
Just because you filed it doesn't mean you can stop either.
Okay.
Got that? Got that? I need to sign it first. All right, at this point, I'm going to sign line 11, which reads, I certify that I specifically informed the offender of her duties as set forth above, and she indicated to me an understanding of those duties. I will sign that at this time. I will have the bailiff make 1, 2, 3, at least 3 copies of that, so all the parties can have that.
Yes, sir.
And then we'll get you a copy of that.
Thank you.
This time the court, again, will proceed to sentencing. I have reviewed the pre-sentence report investigation, psychological evaluation, drug and alcohol evaluation from Dr. Rinsberg, as well as other reports that have been prepared. I've considered the particular facts and circumstances of the offense involved, the nature of the offense and the conduct at issue here. I have received a packet of letters from family, acquaintances, supporters of the defendant. I've read all of those and taken those into consideration. I have considered what's been said here today by Ms. Tuttle, the defendant herself. Consider the comments and recommendation from the state of Ohio. This is all considered in light of the purposes and principles of felony sentencing, which are set forth in 29.29.11 of the revised code. As for the factors in 29.12b, the court finds that the victim here did suffer serious psychological and economic harm as a result of the conduct involved. The relationship with the victim also facilitated the offense. No factors make the conduct, the offense less serious, not the conduct, but the offense less serious than normal. As for recidivism factors, there is a history, albeit brief, but there is a prior delinquency adjudication as well as criminal conviction as an adult. Appears to be a drug problem that relates to the offense as well. No factors indicate recidivism is less likely. This is a felony of second degree, which carries a presumption for prison. And the court's required to impose a prison term unless that presumption can be overcome. And the problem here is that we have an offense in conduct that's involved here, which is extremely dangerous. What she did was extremely egregious, extremely serious. Not only did she light the structure, the place on fire, she spread accelerant on the victim herself, on another person, not just property, but a person. And while the court recognizes mental health issues involved, I also can't ignore the fact that multiple doctors have diagnosed her with malingering when she has been undergoing testing. Not just the county doctor, but also the doctor at North Coast. And when they attempted to do testing, the results were that she was malingering. And there was testing to determine whether there was malingering, and those all tested that, yes, she was. The recommendations also are that if the court's going to consider anything other than prison, it needs to be in a locked facility, and I don't have anything like that being proposed or available. But nonetheless, the nature of the conduct involved here and the offense involved here Considering that, prison's consistent with the purposes and principles of sentencing, and the court finds the defendant is not amenable to any available community control sanctions. There's nothing available. Therefore, it'll be the sentence of this court that on count 2, I believe it is. On count 2, defendant served an indefinite term in prison of a minimum of 5 years, maximum of 7.5 years. She has credit for 343 days that she's already served. I need to advise you, upon your release from prison, you will be placed on post-release control for at least 18 months. It could be up to 3 years. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence here today. Court further orders the defendant to pay all costs incurred in this action. I also need to advise you that there's a presumption that you will be released at the minimum sentence after you've served that term. That presumption is rebuttable, meaning that if the Department of Rehabilitation and Corrections believes basically that while you were in prison you didn't follow the rules, that you committed infractions of the institution's rules, you weren't rehabilitated, that you were a threat to society, that they could rebut that presumption and not release you at the time of your minimum sentence. Though again, there's a presumption that you will be. You have a right to have a hearing if they decide not to. If after that hearing they determine that you did in fact violate rules, they can not release you at your minimum time. They can keep you in there. They can provide then a new date that you can be released, and there'll be a presumption that you will be released on that date. Again, unless you violated the rules of the institution and committed rule infractions, you would be released at that time. Under no circumstances, however, can you be kept in beyond the maximum sentence. So even if you misbehaved the whole time you were in there, you'd have to be released at the expiration of the 7.5 years. I believe that covers everything. Is there anything else for the record, Ms. Mulligan?
No, you don't have to go in there. I'm not
Ms.
doing
Tuttle?
that.
No, Your Honor, thank you.